I'm Melvin L. Raymond, attorney and counselor at law. Welcome to Raymond Law Live. Remember, when you fight, you should know your rights. First, I want to give a shout out to Better Family Life and the Sims and Bailey law firm. Better Family Life is hosting their Kwanzaa Expo from December 16th to the 17th. If you want more information about that event, you can call Better Family Life at area code 314-367-3440, extension 715, or go to their website about the expo at www.betterfamilylife.org. Sims and Bailey is a Central West End law firm providing quality legal services and expert representation in the bi-state area. You can contact Sims and Bailey at area code 314-534-0800. Before I start, with our topic, I want to tell you about a new feature that we've added to the broadcast, and that feature is What's Your Need? This is a new tool where you can tell us what topics you want us to cover in future broadcasts relevant to your needs. Simply email us or telephone us to give us your topic of choice. I will give you the email address and the telephone number before the end of the broadcast. Today's topic is very important because it directly impacts families for better or for worse. And the topic is child support and the rights of both parents, the mother and the father, and the children as well. The support of unemancipated minor children born of a marriage or not born of a marriage is a moral as well as a legal duty for both parents. It is not only the father's duty to support a child or children. The mother also has a duty of support and may be ordered by a court to pay the amount necessary for the support of a child born of a marriage or a child or children not born of the marriage. Now, today I'll be discussing child support in conjunction with a dissolution of marriage and paternity actions, not administrative actions or criminal non-support cases. Those two, administrative actions and criminal non-support cases, will be covered in a future broadcast. Now, in child support cases, the amount of child support to be awarded is determined. Basically, the court is concerned with the needs of the child or children. An award of child support may be made by a court, and the court retains jurisdiction or power over the award of child support if a later modification should arise. Only a court has the power to modify future payments. The parties may not do so of their own accord, with very limited exceptions. Parents, however, can make a binding agreement as to past due support, but they cannot effectively contract regarding future support. Future support may only be dealt with in a motion to modify a judgment of dissolution of marriage or a judgment in a paternity action. Now let's deal with child support in a joint custody case. In situations where the court awards the parties of the marriage or in a paternity action joint custody of a child or children, it is possible that the court may not award support to either party. That can happen in situations of joint custody being awarded to both children. Now, if the financial situations of the party are similar and each parent is awarded joint physical custody that provides for about half of the time will be spent with each parent, then the court may not award child support. However, if the time spent with each party is not equally divided, then the court will award child support to one of the parents. Now, in some cases, the courts in Missouri and maybe even other jurisdictions may award some support even if the parents have joint custody and they are substantially have equal time with the child. It does depend upon the court, so that can happen in instances of joint custody. But the point is that the court need not necessarily award child support in situations where the financial circumstances of the parties are about equal and they are dividing up the time half and half as to physical custody. If the court finds that financial assets and income of both parties are equally balanced, then the court should and probably will not make an award of child support, even if the income of one party is, or one parent, is substantially more than the other. The court looks at financial resources. If the total financial resources of the parties is balanced, then, and that's what the decision to award child support is based on. If the total financial resources of the parents are balanced, that's what's important. Now, what are the factors that the court uses in determining the amount of child support? There are 4 factors under Missouri law that the court looks at in determining in a dissolution of marriage case or a paternity case in determining what amount is going to be awarded. The first is the financial needs of the child. The second is financial needs and resources of the parent. Number 3 is the standard of living of the child. That is the standard of living the child would have enjoyed had the parents not been divorced or had the marriage not been dissolved. And the 4th factor that the court uses in determining child support is the physical and emotional needs of the custodial parent. The physical and emotional needs of the child, and also the educational needs of the child. And that, as far as educational needs, that would include the private schooling of the child. The court can consider that in fashioning an award of child support. The court has to balance the needs of the custodial parent and the children or child against the other parent's ability to pay child support. Again, they balance the needs of the custodial parent and the children against the other parent's ability to pay child support. The primary focus is on the financial status and needs of the parties. The financial status and needs of the parties. Now, of all those factors, the income of the child sometimes is overlooked. And that comes up in the context of modification of child support amounts when you are seeking one of the parents or the parent paying child support is seeking to have the amount changed normally to have it reduced in a modification proceeding. When you have a situation where the court initially awards child support to one parent, and then years later when the child reaches an age where they may begin working part-time in addition to attending school, then if that is the situation, then the court can look at the additional income being earned in a part-time job by the older child who is now working and attending school. So that's another factor there. Now, as far as the Missouri, and this applies in most other jurisdictions, the court has established a presumed child support amount that's established. There's a table that sets forth the presumed child support amount, and there's also a worksheet called a Form 14 in the state of Missouri by which the presumed child support amount is determined and calculated. So we have a Form 14 that the court utilizes, and you have a table of presumed child support amounts. The child support amount, the presumed child support amount, is based on a consideration of the income of both the custodial parent as well as the non-custodial parent. So it's based on certain income levels. Combined income of both parents is considered, and then the amount is set in the table based on the gross amount of monthly income. All the courts in Missouri, throughout the state of Missouri, rely on the presumed child support amount, and that's calculated with a form or worksheet called the Form 14. Now, you were probably wondering, or you may be wondering about the duration of child support. The duty of a non-custodial parent to make support payments abates in whole or in part if a custodial parent, number one, voluntarily relinquishes physical custody of the child for more than 30 consecutive days. So if the custodial parent voluntarily relinquishes the child, gives up the child to the non-custodial parent for 30 consecutive days, then that could work a termination of the child support. Of course, if that does occur, then an action would have to be brought in court to terminate the child support. It's not automatic. And also, the duty of support terminates when 5 other things happen. 5 other things. When the child, number 1, dies. Number 2, marries. 3rd, if the child enters active duty in the military, support would terminate. 4, if the child becomes self-supporting, provided that the custodial parent has relinquished child support, or relinquished custody rather, by implied or express consent. And lastly, 5th, if the child reaches age 18 or graduates from a secondary school, whichever comes later. Some children may not graduate from secondary or high school when they turn 18. If that's the case, then under the law in this jurisdiction, the state of Missouri, the child support would continue until the child graduated from secondary or high school. So that's how long that the non-custodial parent is obligated to pay child support. But there's a big exception to that, termination of child support when the child reaches age 18, if the child is physically or mentally incapacitated from supporting himself, is insolvent, and is unmarried. Then the court in those instances, again, if the child is older than 18 and physically or mentally incapacitated from supporting himself or herself, or is insolvent and is unmarried, then the court can extend child support beyond the age of 18. There's also a situation where the obligation to pay support may continue, and that is when a child continues their education after graduating from secondary or high school. In Missouri, and this may be true in other jurisdictions, but in Missouri, if the child continues his education, his or her education, in an institution of vocational or higher education not later than October 1st following their graduation from secondary school or high school, and continues to attend a vocational or institution of higher education, then the parental obligation continues beyond 18 until the child either completes his education or reaches the age of 21, whichever occurs first. So, if the child goes on to their schooling after graduating from high school, then the obligation to support them would continue. But, as I mentioned, the child has to go on to continue their education the first October after they graduate from high school or secondary school. If they do not go on to continue their education the October following their graduation, then the obligation to pay support does not continue. And also, there are other requirements for support to continue when a child is attending vocational or an institution of higher learning. The child has to carry a minimum of 12 credit hours per semester unless the child is working 15 hours per week, in which case the child only has to carry 9 credit hours. And the second thing, and this is very important, that the child, not the custodial parent, must provide the parent paying support with a schedule of his or her courses that they're going to be taking in the upcoming fall semester prior to each semester, and an official document from the school at the close of each semester indicating the courses taken, the grades for those courses, and the credit hours earned. So that's conditional in order for the child support to continue when the child is over 18 and continues their higher education. Failure to provide this documentation means that the child is not eligible for support during that particular semester. And also, of course, if a child is attending school, they must earn a grade. They must earn a grade in the courses taken. As far as grades, a pass, fail, or a credit, non-credit is not acceptable. They need a grade. So that's something that the court would look at, a grade. So those are the requirements for a child to continue to be eligible to receive support when they turn 18. Don't forget, you can post your questions or your comments anytime, and I'll be able to take your questions and comments during the question and comment section. So we can deal with your questions and comments at this time. I have a question. Can I request a child support adjustment if my wages decrease? The answer is yes. You would have to do that by way of bringing in a modification of the support that has to be brought in court. Now, just because your wages may temporarily decrease, that may not be sufficient for a modification or a reduction of the child support. It depends on the amount of the decrease. If the decrease is not temporary, that is, you've changed jobs and it's another permanent job, and the amount you're making at least 20% less, in that instance, then the court may modify the support. So it can't be a small decrease. It has to be a decrease that's substantial enough for the court to modify the support and reduce the support. So the magic number there is 20%, and it cannot be a temporary increase. It has to be more or less a indefinite increase or decrease in the wages. I have another question here. Can I request an adjustment if I have a new child? The answer is yes. I mentioned the Form 14, which is a worksheet that the courts use to calculate support. You do get an adjustment or a credit if you have a child that you're legally obligated to support. You have to be legally obligated to support the child, and to the extent that you're paying support for a new child that is not the subject of the proceeding where you're paying current support to a custodial parent, then that can be considered, and there's a place on the worksheet to consider an adjustment or credit for the new child. In fact, the child support guidelines, the amount of support is based on the number of children, and if there are new children who are not part of the case where you're presently paying support, then yes, you can get that included. You'd have to, of course, if your circumstances change, and I think a new child is a continuing change circumstance, then that is a basis for the court to recalculate the amount of child support. I have another question here. That question, what if the question is, how does the non-custodial parents becoming disabled, how does that affect the duty to pay child support or the child support obligation? If a parent, the ability of the parent to pay is a factor that the court considers in determining whether or not there's going to be an award of child support. If a parent becomes disabled, the parent that's paying the support, then, and they're not able to pay support, then that may lead to a termination of the obligation of support. However, if the disabled parent is receiving, let's say, Social Security disability benefits or some kind of disability benefits, then that is included as income, and the court would consider that and continue the obligation to pay support based on the income, the disability income being received. That could be any kind of disability. That's still considered as income. In fact, for purposes of child support, income is not only just wages that you earn, but it could be income from any number of sources, including unemployment compensation, including disability benefits that may be paid. It could be annuities and so on. So yes, if you're disabled and you're receiving some kind of disability income from a job or from another source, such as Social Security, then yes, that does not relieve you of the obligation to continue paying support. We're getting near our final segment here. I have one more question. It doesn't relate to child support. The question is, if you're sued by, let me look at this question. If you're a homeowner and you get sued on your homeowner's insurance you sue the host based on the homeowner's insurance, can you sue can the host sue the other person? So if you get sued because of your host under your homeowner's insurance, can the host sue the other person? You have to have a basis for suing someone. You have to have a claim, and if the homeowner, let's say, has a counterclaim or an affirmative defense to the suit, then yes, the homeowner can bring whatever claim they have against the person that's suing them. In the final segment, I want to thank all of you who watched this broadcast live, and also those of you who will be watching later for tuning in. I appreciate your time and interaction. And don't forget, you can contact us by email. Let me leave my email address. There's two of them. You can reach me at my email address. That's mraymond_attorney, mraymondAttorney. That's a long one. mraymondattorney at sbcglobal.net, sbcglobal.net. Or you can reach me on my office telephone number at area code 314-534-2800. Again, my office telephone number is area code 314-534-2800. And you can also, for further comments or questions, you can contact us on our Facebook page. Go to facebook.com/RaymondLawLive.com or the website, that's RaymondLawLive.com, or Twitter, that's Twitter at RaymondLawLive. And don't forget to send us your topics for that you want us to cover in future broadcasts. Finally, I want to give a shout out to Better Family Life and their Kwanzaa Expo on December 16th and 17th. Please contact them for information about that event at their phone number, area code 314-367-3440, extension 715, or www.betterfamilylife.org. And the Sims and Bailey Law Firm, they're in the Central West End. They provide quality legal services and expert legal representation. Contact them at area code 314-534-0800. We will see you next Tuesday at 6 p.m. Central Time. And remember, when you fight, you should know your rights.